Well, the findings of the much-anticipated psychologist and psychiatric reports were read into the court record earlier. Advocate Barry Rue read out the details of the psychologist's report, followed by Gerinel reading from the psychiatrist's report.
Completeness sake, my lady, read at page 29 the evaluation, just to put that before the court. That's page 29 of the psychologist's report. It's a report that was commissioned by you, requested by you by Professor J.G. Scholz, dated 27 June 2014, and the background is there and all the tests done are there. It may be dealt with, I believe, in argument ultimately. And then the evaluation is page 29, and it says the following. From my assessment of Mr. Pistorius and with the information currently at my disposal, I come to the following conclusions. 5.1. Mr. Pistorius has been severely traumatized by the events that took place on the 14th of February 2014. He currently suffers from a post-traumatic stress disorder and a major depressive disorder as defined by Diagnostic and Statistical Manual 5 in brackets DSM-5. See Annexure C. The degree of anxiety and depression that is present is significant. He is also mourning the loss of Ms. Steenkamp. 5.2. Mr. Pistorius is being treated and should continue to receive clinical care by a psychiatrist and a clinical psychologist for his current condition. Should he not receive proper clinical care, his condition is likely to worsen and increase the risk for suicide, and then a reference to references. 5.3. No evidence could be found to indicate that Mr. Pistorius has the history of abnormal aggression or explosive violence. Abnormal aggression and violence was never incorporated into his personality, as borne out by both psychometric testing and collateral information. He does not display the personality characteristics of narcissism and or psychopathy that are mostly associated with men in abusive relationships and have been linked to rage-type murders in intimate relationships. Those who know him describe him as gentle, respectful, and conflict avoidant. The times when he did become angry were found to be suitable for the situation and context. His style of conflict resolution is to talk through the situation or remove himself from the situation. He also has the ability to self-reflect afterwards, mostly leading to feelings of guilt and an apology from him. His ability to regulate his affect is well developed. 5.4. There is evidence to indicate that Mr. Pistorius does have a history of feeling insecure and vulnerable, especially when he's without his prosthesis. He has also been exposed to crime directly and indirectly throughout his life. A reaction to a threatening situation comprises more than flight or fight. An appraisal takes place instantly, whereby the individual assesses firstly the intensity of the threat and then is positioned to cope with the threat. These appraisals are influenced by, amongst other things, previous experience. When Mr. Pistorius' appraisal of a situation is that he might be physically threatened, a fear response follows, which might seem extraordinary when viewed from the perspective of an able-bodied person, but normal in the context of a disabled person with his history. 5.5. No evidence could be found to indicate that Mr. Pistorius suffered from anxiety to the extent that it impaired his functioning prior to the incident in February 2014. He specifically does not meet criteria D for the DSM-5 for generalized anxiety disorder. Quote, the anxiety, worry, or physical symptoms cause clinically significant distress or impairment in social, occupational, or other important areas of functioning. That's also referred to in Annexure C. If his context is taken into account, his function was superior prior to the incident in February 2014. For somebody of his age, his achievements in both his occupation and the social sphere were enormous. The successful intimate relationship he craved and his inability to rehabilitate his relationship with his father being the only areas where he achieved less success. 5.6. There is evidence to indicate that Mr. Pistorius was genuine with his feelings towards Ms. Steenkamp and that they had a normal, loving relationship. He did become insecure and jealous at times, but this was normal for the specific situation. He would express his displeasure and irritation, but would try and sort it out Later, by talking with Ms. Steenkamp, although the relationship was still young, there were no signs of abuse or coercion like those often found in these kinds of relationships, and then reference to previous works by experts. In his previous long-term relationship of 4 years, these aspects were also absent. And then the findings, which were previously read into the record, just as to his mental state. So,
the psychosocial report was compiled, psychometrics was done, and the psychological report was compiled. Documentation that was produced included a case docket and official court proceedings report, a medical record from Mill Park Hospital about treatment received during 2009, psychiatric report by Professor M. Foster, report by Dr. R.G. Holmes. Then B, psychiatric diagnosis at the time of the alleged offence according to DSM-5, none. Currently, the accused presents with an adjustment disorder with mixed anxiety and depressed mood that developed after the alleged incident. This has no bearing on paragraph C. Paragraph C reads, at the time of the alleged offences, the accused did not suffer from a mental disorder or a mental defect that affected his ability to distinguish between the rightful and wrongful nature of his deeds. A mental disorder or mental defect did not affect his ability to act in accordance with the said appreciation of the rightful or wrongful nature of his deeds.
All right, I'm still in the studio with Chris Greenland, and just looking at those highlights. Nel is quite clear that what adjustment disorder was found, as far as the Vescorpi's reports were concerned, relates to Oscar Pistorius' state of mind after the incident. As far as GAD is concerned, none. There were no signs that said he meets the standard as required to then say that was an influencing factor on the night in question.
Absolutely correct. I mean, Oscar's emotional and psychological state after the event doesn't take his case appreciably further down the road, because whether he's guilty or innocent, whether he killed Riva in cold blood or not, you'd still expect him as a normal human being, and having done this out of character, to feel traumatized afterwards.
One of the things we need to understand in all of this, I mean, we've had a lot of evidence today around disability and how disabled people might react differently versus people, you know, with their full abilities in situations of perceived threat. Does this, in a way, almost imply that disability might lead to someone being unreasonable in a situation? I mean, it's a very thin...
Bongani,
they're in thin ice here, aren't they?
I think you've put your finger on it. We've got all this evidence as to how a person who's disabled and challenged will react with a heightened fight reaction. But it presupposes that there is a threat. So if we take the facts in question and we say that the situation was that a window broke, and after there was a sound of a window breaking, and after this was confirmed that there was an intruder, then I would say that this evidence is extremely valuable, because any person, disabled or not, would then feel threatened. So the fundamental question here is this point: a bump in the night, in the security and sanctity of your own home, does a reasonable person feel threatened? I would say no. And these reports don't say disabled people are unreasonable. What they say is that when they are threatened, they will have a heightened fight-flight response.
But it doesn't for a moment suggest that because one is disabled, you therefore start unreasonably perceiving threats where there are none.
That's the way I see it. That's the way I interpret the evidence. I don't think these experts are saying that disabled people are unreasonable.
One of the things that you legal experts have said over and over here on Channel 199 is this idea that the defense has to only offer a version that is reasonably possibly true. I mean, Aren't they doing that with these explanations?
Yes and no. We've been down this road before. And I can explain it like this. If I pull out a pistol now and point it at you and shoot you dead, I'm guilty of murder if nothing else happens. The state simply needs to prove that. If nothing else happens, I'm guilty of murder. I can't get out of it unless I convince the court of an excuse that is legally supportable.
Well,
in other words, I have to show that killing of you is legally excusable.
Judge, I'm going to have to interrupt you right there because we're going to go to a quick ad break, but we'll talk about what might be required for that to be the case. After the break, as I say, we'll continue to bring you highlights from court today and analysis with former Judge Chris Greenland.